on connecting our grid more to other parts of the country to deliver electricity to us. What that really means, we don't like windmills. We don't like to look at them in Boston Harbor. We don't like offshore wind. We want windmills built in Oklahoma, and you guys just ship us our electricity so we can flick on the light. Ms. Laura Daniels Davis. She's been nominated to be Assistant Secretary for the Office of Land and Minerals Management. She's currently in a role already with DOI. In her role in DOI, she's already made the change that routine permitting decisions that are typically made in the field to expedite process of making permits, those have all been pulled up to her desk in Washington, D.C., where they've slowed down dramatically. The clear signal was, if you want to do any oil and gas development, it's got to come through me, and it's not going to be rapid like it used to be. So if you're going to invest capital, just understand your capital is whether I make that decision or not. They've not held a single onshore oil and gas lease sale, even though they're required by law to do so. Just ignored it for a year and said, we're studying it. There's also a 5-year leasing plan that's required for offshore oil and gas development. So while they've cut off offshore, there's a 5-year lease plan that has to be put in place that's due by June of this year. So far, we have no signal they've even begun that, and it takes months to be able to develop. Why are these individuals being selected for these positions? Because it's very clear they have certain priorities in place. They were selected because they're going to block out anything that deals with oil and gas, and their focus is to cut it off right now. Cut off pipelines, cut off new leasing, cut off offshore leasing, make it harder to be able to get access to capital. All of that will raise prices for American consumers. Today, it was announced the inflation rate in the United States is now at 7.5%. It continues to rise month after month after month. I would say to you that is directly connected to a group of policies that have been put in place to make energy more expensive, and it is, to make it more difficult to be able to do a lot of things in permitting and such, and it is. Yes, we're recovering from COVID, I'm very aware. But the policies that are put in place are also driving this. We have 2 million people that have illegally crossed the border last year. 2 million. That's an enormous number. That 2 million number did not happen by just the calendar and by COVID. Policies were put in place that have led to a flood of people illegally crossing our border. Policies are being put in place by individuals that are directly leading to 7.5% inflation now in our country. Can I say to you, half of the Americans alive have never in their lifetime experienced inflation like they're experiencing right now. Half of the Americans alive do not know what 7.5% inflation is going to be to them personally, but they're learning quickly because what they thought they were going to buy last month, they can no longer afford this month, and it doesn't look better next month. And if we don't deal with real consequences for people, including who is put into different positions, this never gets better. I yield the floor.
President. Mr. President.
Senator from Washington.
I ask that the scheduled vote occur immediately.
Without objection. The question is on the nomination.
I ask, Mr. President.
Is there a sufficient second? There appears to be. The clerk will call the roll.
Mr. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Braun, Mr. Brown, Mr. Burr, Ms. Cantwell. Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Arono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Tuberville, Mr. Van Hollen, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Booker, Cantwell, Casey, Duckworth, Durbin, Gillibrand, King, Markey, Merkley, Murray, Ossoff, Schatz, Schumer, Shaheen, Sinema, Smith. Senators voting in the negative: Cassidy, Crapo, Graham, Heidsmith, Inhofe, Johnson, Kennedy, Langford, Paul, Sass, Scott of Florida, Tillis, Toomey, Tuberville, Young. Ms. Hassan, aye. Mr. Grassley, no. Mr. Hoven, no. Mr. Hawley, no. Mr. Whitehouse, aye. Ms. Warren, aye. Mr. Shelby, Mr. Shelby, no. Mr. Menendez, Mr. Menendez, aye. Mr. Reed, aye. Mr. Murphy, aye. Mr. Bennett, aye. Mr. Heinrich, aye. Mr. Brown, aye. Ms. Baldwin, aye. Ms. Ernst, no. Mr. Braun, no. Mr. Rubio, no. Mr. Daines, no. Mrs. Feinstein, aye. Mr. Manchin, aye. Mr. Leahy, aye. Ms. Cortez Masto, aye. Mr. Marshall, no. Mr. Cornyn, no. Mr. Tester, aye. Mr. Cruz. Mr. Cruz, no. Mr. Rounds. Mr. Rounds, no. Mr. Kramer. Mr. Kramer, no. Mr. Scott of South Carolina, no. Ms. Rosen, aye. Mrs. Blackburn, no. Ms. Moran. Mr. Moran, no. Mr. Van Hollen. Aye. Mr. Van Hollen, aye. Mr. Wyden, aye. Mr. Lee, no. Mr. Bozeman, no. Mr. Portman, no. Mr. Sullivan, aye. Ms. Collins, aye. Mr. Wicker, no. Mr. Risch, no. Mrs. Capito, no. Mr. Kelly, aye. Mr. Cotton, Mr. Cotton, no. Ms. Murkowski, aye. Mr. McConnell, no. Mr. Peters, aye. I tell you. Ms. Klobuchar, aye. Mr. Romney, no. Mr. Hickenlooper, aye. Mr. Carper, aye. Mr. Thune, no. Mr. Warnock, aye. Mr. Wyden. Mrs. Stabenow, aye. Mr. Warner, aye.
Do we have any wrap-up?
Mr. Coons, aye. Mrs. Fisher, no. Ms. Hirono, aye. Mr. Kane, aye. Mr. Carden, aye. Mr. Blumenthal, aye. Ms. Lummis, no. Mr. Padilla, aye.
The yeas are 51, the nays 43, and the nomination is confirmed. Under the previous order, the motion to reconsider is considered made, laid upon the table, and the President will be immediately notified of the Senate's actions. Thank you.
Mr. President.
The senior senator from Maryland is recognized.
Thank you, Mr. President. I ask consent that the Senate resume legislative session.
Without objection.
Mr. President. Mr. President, I rise today in recognition of Black History Month. Black History Month provides an opportunity for our nation collectively to reflect on and celebrate the contribution and legacies of Black Americans. And while we have chosen this month, February, to engage in collective celebration, we must also remember that we benefit from the contributions and legacies of these great Americans every single day. Today, I would like to focus my remarks on our nation's black entrepreneurs. From Madam C.J. Walker to Baltimore's own Reginald F. Lewis and beyond, Black entrepreneurs have long been vital to the success of the American economy. Unfortunately, throughout history, those who seek to hold back the progress of the Black community view the successes of Black entrepreneurs as a threat. One need only look to the 1921 Tulsa Massacre, a dark incident in our nation's history that has belatedly entered our collective consciousness. White residents of Tulsa, Oklahoma, bombed, burned, and destroyed the Greenwood District. In addition to an untold number of lives lost, estimates range from dozens to hundreds, the riot destroyed homes, churches, schools, and businesses in the district. At the time, Greenwood was known as Black Wall Street due to its thriving Black middle class and successful businesses, and its destruction was one of the worst instances of racial violence in our nation's history. It is with instances like Greenwood and the dozens like it in mind that I stand here today, because while Black entrepreneurs no longer work under the threat of such violence, they still face many long-standing systemic barriers. My late friend and mentor, former Congressman Parren J. Mitchell, believed very strongly that the federal government had an important role to play in our efforts to right these historical injustices and support Black entrepreneurs. In 1977, Congressman Mitchell fought to pass an amendment to a $4 billion federal public works program requiring city and state recipients to set aside 10% of the funds for minority-owned businesses. He would go on to call the amendment his proudest congressional accomplishment. I was incredibly proud last year to build on his legacy by working across the aisle and finally codifying the Minority Business Development Agency, MBDA, and giving the agency the resources and leadership necessary to help support entrepreneurs in Black and other minority communities. This accomplishment is particularly important in Maryland, as the presiding officer knows, since we are the home to the highest concentration of minority-owned businesses in the country. While we have made progress, we must also continue working together to address these systemic inequities. At the height of the pandemic, we came together to create the Paycheck Protection Program, the PPP program, and we worked in a bipartisan manner to improve the program once it became clear that it was leaving far too many of our most vulnerable small businesses behind. We invested in non-bank financial institutions like the Community Depository Financial Institutions and microlenders. We strengthened relationships between the Small Business Administration and our nation's historically Black colleges and universities and minority-serving institutions. We created grant programs that reduce structural barriers instead of reinforcing them. Recent studies have shown that these policies directly address the inequities present during the Phase 1 PPP, which favored larger businesses. Through thoughtful policy, we made the programs more equitable, with the share of loans made to minority-owned businesses during Phase 2 and 3 of the program in proportion with their overall share of small businesses. As I speak here today, the Senate is still trying to find a path forward on President Biden's Build Back Better budget, which implements many of the lessons we have learned over the past 2 years. The bill contains many key provisions that will enable the SBA and MBDA with resources to empower Black entrepreneurs even more. For instance, the Build Back Better Act would create a direct loan program at the SBA. It would create a new Uplift Accelerator program to deepen relationships between the SBA and HBCUs. And it would make the SBA's existing loan products more accessible and affordable. The pandemic has demonstrated that when we come together to address the problems in our society free from partisanship and in good faith, we're able to make great strides. It also confirms that the federal government has a key role to play in addressing the historic injustices that have harmed and continue to harm Black entrepreneurs and the Black community at large. This Black History Month, let us commit to pairing our words with actions, just as we did during the pandemic. We need to enact these proven policies as quickly as possible. We cannot let this opportunity pass us by. Mr. President, with that, I would suggest the absence of quorum and yield the floor.
The clerk will call the roll.
Ms. Baldwin.
Mr. President.
The senator from Nebraska is recognized.
Thank you, Mr. President. I rise today to celebrate the distinguished...
Sorry, the Senate's in a quorum call.
Thank you. I would ask that it be vitiated, please.
Without objection.
Thank you. Mr. President, I rise today to celebrate the distinguished career of a Nebraska public servant, United States District Court Judge John Girard. After just over 10 years on the federal bench in the District of Nebraska, he announced Monday that he will move to senior status starting next year. Judge Girard's impressive career has spanned more than 4 decades, and it's not over yet. After his successor is confirmed, he will remain on the bench with a reduced caseload. Judge Girard is a native Nebraskan. He grew up in Schuyler and attended Nebraska Wesleyan University in Lincoln. He left the good life temporarily to pursue an MPA at the University of Arizona and a JD at the University of the Pacific in California. I am grateful that he came home to Nebraska after law school. In 1981, Judge Girard began his career in the private practice in Norfolk. A year later, he also began serving as a part-time city attorney for the neighboring community of Battle Creek. That was the start of 40 years and counting of selfless public service. In 1995, he was appointed to the Nebraska Supreme Court by then-Governor Ben Nelson. He was just 41 years old at the time, making him the youngest ever Nebraska Supreme Court Justice. And after more than 15 years on our state's highest court, he was nominated by President Obama to the federal judgeship he holds now in 2011, serving as chief judge for 3 of those years. At every turn, Judge Girard has used his respect for the law to advance the greater good of Nebraskans and all Americans. During his time on the bench, I have appreciated hearing his views about many pressing judicial matters. His perspective as a sentencing judge has also been crucial in helping me to unpack how proposed legislation in Congress would affect federal judges. It's been an honor to know Judge Girard and to work with him for over a decade. He is an accomplished, skilled, and respected jurist, and I am glad that he has chosen to continue his service after moving to senior status. Everyone who knows Judge Girard can attest that his wisdom extends far beyond the law. He has never failed to impress me with his keen observations about life. He is a good man with a servant's heart, and I am proud to call him a friend. On behalf of all Nebraskans, I would like to thank him for his 4 decades of dedicated public service. I look forward to working with President Biden to confirm a district court judge who will live up to Judge Girard's legacy of ruling fairly in accordance with the Constitution. Thank you, Mr. President. I yield the floor. I would suggest the absence of a quorum.
The clerk will call the roll.
Ms. Baldwin.
Mr. President,
The senator from Kansas is recognized.
I ask unanimous consent the quorum call be lifted.
Without objection.
Mr. President, thank you. Last month, the American Red Cross began sounding the alarm on a national blood crisis, the first they have ever declared. COVID-19 has added extra volatility to the blood supply, and this shortage strains hospitals and patient care throughout America. We continue to face the critical blood supply shortage today, with Kansas's blood supply standing at a 1 to 2 day inventory. I've heard from medical professionals, doctors and nurses, others in Kansas about the tough decisions rural doctors and healthcare providers are having to make, including canceling surgeries, blood transfusions, and possibly not delivering babies because bleeding complications may require blood that these facilities just don't have. My hometown is Plainville, Kansas, a population about 2,000. We're fortunate to have a county hospital with dedicated healthcare professionals and physicians. One of my hometown physicians, Dr. Sanchez, who I'm told is not on Facebook very often, but posted his plea for people to donate blood. Dr. Sanchez's Facebook post says, this is his story. Today we had to tell a patient with heart disease that the blood transfusions that have prolonged his life with marked improvement in quality could no longer happen at Rooks County Health Center. My patient and his son were understandably upset. It just so happens that the same patient was told a few days previous that the melanoma cancer that he'd beat for 40 years back returned. And now, no blood transfusion. The doctor says that the hospital is considering canceling surgeries, possibly even not delivering babies. Our stock of common blood type A positive and donor O positive blood units are down over 30%, from 6 units to 4 units. The universal donor O negative blood has been in short supply for months, maybe for years. Blood supplies are usually replenished at the American Red Cross every 3 weeks, but we've had no new units given or replaced. That's one doctor, one hometown, one hospital, but it's people in Kansas, it's people in this country who we know and care for, people we love, people within our families, and people we don't even know. The most vulnerable patients among us rely on blood donations for transfusions to support essential treatments, such as those of battling cancer or living with chronic diseases. There is no substitute, there's no alternative. Our nation can turn to the absence of blood donations. The only answer is for each of us to stepping up to donate, helping to end this crisis and contributing to saving lives of those in our communities. The shortage is severe, and it's affecting Kansas health providers and their ability to care for their patients. It will cost us lives. Kansans pull together in times of need, and I encourage everyone in Kansas and across the country to donate. In the United States, every 2 seconds someone needs blood or platelets, and donating blood is one of the most tangible actions we can give to help save lives. Donation centers provide specific guidance on blood donation process and safety measures taken within their centers. You can find a location that's accepting blood donations near you. You could visit the American Red Cross website. And so just the plea that we all consider donating blood to help save the lives of our friends, our neighbors, our fellow Americans. Mr. President, I yield the floor and note the absence of a quorum.
The clerk will call the roll.
Ms. Baldwin.
Madam President,
Assistant Majority Leader.
are we in a quorum call?
We are,
I ask unanimous consent that we suspend the quorum call.
without objection.
Madam President, I ask unanimous consent that my following remarks appear in the record after the remarks of Senator Lindsey Graham of South Carolina this morning.
Without objection.
Madam President, this body is at its best when we come together to support the most vulnerable people in America. Earlier today, we did just that by passing the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And in the coming days, we'll have a chance to do it again with the Violence Against Women Act reauthorization for 2022. Both of these bills are the product of months of bipartisan negotiations, and they will ensure that survivors of domestic violence and sexual assault can reach for a lifeline in a moment of crisis and seek justice against their abusers. At a time when nearly 1 in 3 women living today say they have experienced some form of physical or sexual violence, this Senate must be united in standing with the survivors. With these two pieces of legislation, we can prove to them and every survivor in America that they are truly not alone. Each day in America, our domestic violence hotlines receive roughly 20,000 calls from victims or people who are at risk of intimate partner violence. That number is a sobering reminder that the crisis of sexual and domestic violence touches every community in America. We need to ensure that every victim, whether they live in a Native community in rural Alaska or in a city like Chicago or Las Vegas, they can reach for help and they're going to get it. Yesterday, I joined Senator Feinstein, Senator Ernst, Murkowski, and 16 of our Democratic and Republican colleagues in introducing the reauthorization of the Violence Against Women Act, known as VAWA. Since it was first enacted nearly 30 years ago, it has transformed the way we deal with domestic and sexual violence in this nation. It has saved countless lives. Let me tell you about one of them. Her name is Megan. Years ago, she was brutally assaulted by her ex-husband. The beating was so violent that she's still suffering from a hearing loss today. While Megan was being attacked, her 2.5-year-old son, who is on the autism spectrum, ran over to help his mom. As he was running, the ex-husband picked up the child and threw him into the closet. Megan said the experience was so traumatizing that her son didn't speak for fully a year after the attack. When Megan finally broke free from her ex-husband, she packed her bags, buckled her 2 kids in the car, and ran for her life. Today, her ex-husband is on the run with 6 open warrants for his arrest. Megan says she and the kids are constantly looking over their shoulders. As Megan and her family have begun to heal from this horrifying ordeal, she says they have found much-needed compassion and support in the law enforcement and social workers who came to their aid. She wrote that service providers, quote, were patient with me and didn't push me. They only showed me they cared and most of all, didn't give up. With their support and guidance, I found the light at the end of the tunnel, and I fought my way out of darkness, the darkness my ex-husband had cast on my life. Megan's story is just one example of the world of difference VAWA has made for victims of sexual and domestic violence. In her case, VAWA provided critical resources to law enforcement and social service agencies that helped her and her family escape the danger. And with the bill we introduced yesterday to update and modernize VAWA, we can build on that legacy. To be sure, this legislation is a compromise. It doesn't include every provision I wanted, not every provision that Senators Feinstein, Ernst, or Murkowski wanted either. But it will deliver critical assistance to survivors across the country, including funding for legal services, trauma-informed law enforcement, access to services for survivors who require culturally specific care, like LGBTQ survivors, survivors with disabilities, survivors in rural areas, and members of other underserved communities. We've crafted a proposal that will save lives and has a pathway to passage in the Senate. In fact, the broad bipartisan coalition in support of this effort was on full display yesterday when we announced this legislation alongside survivors, advocates, district attorneys, Baltimore Police Commissioner, oh, and yes, the actress Angelina Jolie. Let me just say, if Athena, the goddess of war, can't convince 60 senators to support this bill, well, I certainly have my work cut out as whip. It's been 9 years since we last reauthorized VAWA, and 4 years since that reauthorization expired. 4 years without a bill. Survivors can't wait no longer. Let's send this law to President Biden as soon as possible. And Madam President, there's one more thing we can do to support survivors of sexual misconduct. These acts of abuse and harassment leave behind scars, visible and invisible, that can last a lifetime. Every survivor deserves the right to seek justice on their own terms. That's why this morning the Senate voted to enact the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. It was introduced in the House by my friend, my longtime friend, since she was 8 years old, and Illinois congressional colleague, Congresswoman Sherry Bustos. It was passed in that chamber on Monday with a resounding bipartisan vote of 335 to 97. My hat's off to Sherry for her hard work and dedication on this issue. A few hours ago, the members of the Senate joined the House in passing this legislation on a bipartisan basis. And this version of the bill was introduced last year by two real fighters, Senator Kirsten Gillibrand and Lindsey Graham, and myself. The premise of this legislation is simple. Survivors of sexual assault or harassment deserve a day in court if that's what they wish. They should be able to choose whether to bring a case forward instead of being forced into secret arbitration proceedings where the deck is often stacked against them. It's becoming increasingly clear that the forced arbitration clauses have enabled sexual abusers to escape scrutiny while their victims are compelled to stay silent. That is just plain wrong. Survivors deserve accountability, and that's exactly what this law will deliver. Far too many survivors have been locked out of the court system because of forced arbitration clause buried in the fine print of their employment contract. Consider the case of Lily Silbert. She had a monthly membership to a therapeutic massage company. It was called Massage Envy. And one day, she was sexually assaulted by a massage therapist. Afterwards, she tried to cancel her membership. To do so, she had to download the company's app and agree to its terms and conditions. There was one detail buried deep within those terms and conditions, a forced arbitration clause. She didn't even know it was there. So when she tried to file a lawsuit against the company, they responded by trying to force her into secret arbitration proceedings rather than a day in court. Even national figures have been trapped by forced arbitration clauses. People like Gretchen Carlson, the journalist and Fox News anchor who has been a champion in bringing this issue to light. She was at our press conference today on the subject. You may remember that Ms. Carlson brought up a sexual harassment case against her former boss, Roger Ailes. He responded by invoking a forced arbitration clause in her employment agreement with Fox. Forced arbitration clauses not only deny survivors their right to a day in court, they also conceal their allegations from the public. That is a green light for abusers to continue harming and harassing victims. Hidden in fine print, these agreements silence survivors and enable abusers. It is time to end this injustice. The bill we pass today will ensure that every survivor has the choice to go to court. It will not change the law around what constitutes sexual harassment or assault at all, but it will give survivors a choice of whether or not to bring a claim in court after the sexual assault or harassment claim has arisen, notwithstanding the presence of a forced arbitration clause. There are a few other points about the bill I want to emphasize clearly on this day of passage. The senator from Iowa discussed her concerns about the bill being used to move claims that are, quote, unrelated, end of quote, to allegations of sexual harassment or sexual assault. The bill is clear on this point. Under the bill, if the survivor so chooses, no pre-dispute arbitration agreement shall be valid or enforceable, quote, with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or the sexual harassment dispute, end of quote. That resolves the senator's concern. I do want to clarify, though, that the bill text does not require any court to adopt new dismissal mechanisms for survivors' claims. Current state or federal law governs how and when a case moves forward, and the bill does not create any new mechanism to allow for dismissal, nor does it require that victims have to prove a sexual assault or harassment claim before the rest of their related case can proceed in court. Furthermore, the bill should not be interpreted to require that if a sexual assault or harassment claim is brought forward in conjunction with another related claim, and the assault or harassment claim is later dismissed, the court must remand the other claim back to forced arbitration. That is not required by the bill. There is nothing in the bill directing courts to dismiss related claims and compel them to forced arbitration if a victim ultimately does not prevail on her sexual assault or harassment claim. If there were such a requirement, it would have the undesirable effect of hiding corporate behavior, such as retaliation and discrimination against women who report assaults and harassment. Take the real world of Miss Taylor Gilbert. In 2015, at the age of 22, she started working for a company called Indeed Incorporated. While at a company training at a hotel, she was assaulted and raped by a company manager. Fearing she would lose her job, she did not initially report the assault to the company, but after repeated further sexual harassment from colleagues, she filed complaints with the company and told her supervisor what had happened. The company took no action, and Ms. Gilbert claimed she faced retaliation for having reported her complaints, including being bypassed for promotions and raises. Ms. Gilbert tried to bring a case in court against the manager who raped her and against the company, not just for the rape and harassment, but also for the retaliation that adversely affected her career path. But there was a forced arbitration clause in her employment contract. Her case was sent to forced arbitration. Under this bill that we passed today, that will change. Her case and all of the claims were related to assault and harassment. Under the bill we passed, the survivor would get the choice to bring the case in court, and the bill does not require dismissal of some claims in the case if other claims are not ultimately proven. In Ms. Gilbert's case, it was essential that the company's conduct in enabling the abuse and harassment and also retaliating against her be brought to light, not covered up by being separated and forced into arbitration. So to clarify, for cases which involve conduct that is related to a sexual harassment dispute or sexual assault dispute, survivors should be allowed to proceed with their full case in court, regardless of which claims are ultimately proven. I'm very happy that's what the bill specifically provides. With this bill becoming law, survivors like Lily Silbert, Gretchen Carlson, Taylor Gilbert will finally have the right to make their case in court, and it will prevent abusers, along with those who enable them, from hiding behind a veil of secrecy. Thanks again to my colleague, Congresswoman Sherry Bustos. Her leadership on this matter will make a difference in many days to come. And I want to thank Senator Gillibrand, a tiger of a leader in the United States Senate, and Lindsey Graham for joining her in this effort, for all the work they put in. Senator Graham has been a vital partner in this effort. He held a hearing on the legislation when he chaired the same committee, and he's been a great partner in getting across the finish line. Finally, I want to thank the members of my staff who worked day and night, literally, on this legislation. Alexandra Lowe-Server on Senator Gillibrand's staff, Catherine Nikas on Senator Graham's staff, and most of all, Shauna Winters on my Judiciary Committee staff who worked so hard. Today's been a historic day in the United States Senate. With the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, the rights of every survivor will be protected. Madam President, I ask unanimous consent that the Senate be in a period of morning business with senators permitted to speak therein for up to 10 minutes each.
Without objection.
I ask unanimous consent that pursuant to the order of the Senate of January 24th, 1901, the traditional reading of Washington's farewell address take place on Monday, February 28th, following the prayer and pledge. Further, that Senator Leahy be recognized to deliver the address.
Without objection.
Madam President, I ask unanimous consent that the appointments at the desk appear separately in the record as if made by the chair.
Without objection.
I ask unanimous consent that the Senate proceed to the immediate consideration of H. Con Res. 69, received from the House and at the desk.
The clerk will report.
H. Con Res. 69, providing for a joint session of Congress to receive a message from the President.
Without objection, the Senate will proceed.
I ask unanimous consent the resolution be agreed to and the motion to reconsider be considered made and laid upon the table.
Without objection.
I ask unanimous consent the Commerce Committee be discharged from further consideration and the Senate now proceed to S. Res. 467.
The clerk will report.
SRES 467, recognizing the contributions made by the 305-meter radio telescope at the Arecibo Observatory.
Without objection. The committee is discharged and the Senate will proceed.
I ask unanimous consent the Blumenthal amendment at the desk to the resolution be agreed to. The resolution as amended be agreed to. The Blumenthal amendment at the desk to the preamble be agreed to. The preamble as amended be agreed to, and that the motions to reconsider be considered made and laid upon the table.
Without objection.
I ask unanimous consent the Senate proceed to the consideration of SRES 510 submitted earlier today.
The clerk will report.
SRES 510, recognizing January 25, 2022 as National Poll Worker Recruitment Day.
Without objection, the Senate will proceed.
I ask unanimous consent the resolution be agreed to. The motion to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
Madam President, I ask unanimous consent that when the Senate completes its business today, it adjourn until 3 p.m. on Monday, February 14th, that following the prayer and pledge, the morning hour be deemed expired, the journal of proceedings be approved to date, the time for the two leaders be reserved for their use later in the day, and morning business be closed, that upon the conclusion of morning business, the Senate resume consideration of the motion to proceed to calendar number 266, H.R. 3076, the Postal Service Reform Act, that the cloture motions filed during today's session of the Senate ripen at 5:30 p.m.
Without objection.
For the information of senators, we expect to have a roll call vote at 5:30 p.m. on Monday